This is an appeal brought with the permission of the district judge against an order for possession. He transferred the case to the Court of Appeal, and Lady Justice Andrews retained it in this court. The issue is about the application of the Tenant Fees Act 2019.
Yes. We've read the judgment and we've read the skeleton argument, so we know what's an issue on the appeal.
Well, my lord, I'm grateful, and the issue, obviously we agree that the act's not retrospective in any relevant sense, but this is a case of payment made before the act came into force.
Yes.
And the question is how it should be treated on the grant of further tenancies between the same parties. And in a nutshell, the case is that the respondent was successively under a duty to return the payment when each tenancy came to an end, and by retaining it on each occasion, he required and received a prohibited payment, and so is unable to serve a Section 21 notice. It raises issues that are similar, but not, we accept, the same, as those that arose in an earlier case of Superstrike and Rodriguez, but the district judge distinguished that case. Although the skeletons raise some complicated issues, this is at heart, we suggest, a case about what inferences are permissible in a case like this. The essence of the case is that the district judge erred in regarding the scope of such inferences as being too restrictive. What I propose to do is deal very briefly with the facts, the tenancies and the terms we rely on. That fixes some points of dispute between the parties by going through those. I'm then going to take you to the relevant provisions of the Act, and then come on to what inferences we say ought to have been drawn, and then seek to explain how those fit with the requirements of the Act. In the course of doing so, I expect I'll pick up most or many of the points that are raised against us in the respondent's skeleton.
Right.
So to come to the facts, the appellant's the tenant of a flat in North London, and she's held the premises under a series of assured short-hold tenancies. We say 4, because the 4th continued as a periodic tenancy. The respondent says 5, because they say the last tenancy was a statutory periodic tenancy, but perhaps nothing much turns on that for reasons I'll come to. The first 2 of those tenancies were entered before the Act came into force. The others were after that. And so if we go to the first tenancy, it was granted on 13th of April 2018. You find it at page 90 of the supplemental bundle.
Yeah.
And we can see that the term...
Do you want to turn it up?
Yes, please. And we see that the term at page 91 is the period from including commencement date to the expiration date.
Sorry, wait a minute. 91.
91.
Oh, yes.
So, and the at the page 92, clause 2, we see it's for a term from the 13th of April to the 12th of April 2019 at £1,400 a calendar month, and 4.2 makes provision for a deposit, and 4.3 says what the deposit's for. Then if I can ask you to go to page 97, there is an obligation to pay £25 there, 5.43 for a missed appointment, and then if one goes to page 1...
That never happened, though, did it?
That never happened. And then page 100, we've got 5.18 for sum of £120 plus VAT for the preparation of what was being described as a renewal fee. And then at page 101, paragraph 5.21, to pay the costs of an inventory and checkout. But one can see that that's not quantified, and the obligation arises at the expiry or sooner termination of the tenancy. Now, before, in fact shortly after the tenancy was entered into, the claimant paid the certain amounts, and if we go to the core bundle, we can see what those were. Page 108. And we see that various amounts are credited, the amount received by the landlords on the 19th, the amount paid by the appellant earlier than that, of 4,799, and we can see what that's allocated to. Part of it's the deposit, part of it's the rent, but one then also sees there's an admin fee, £240. You'll recall that the admin fee was £120. And there's also a new checkout, it says, £144. And
these seem to be credited against the rent.
Well, they're credited against a payment that was made of 4,799.
Yeah.
So you've got a debit and credit column, but that perhaps tells us nothing very much about the nature of the payments. They are referenced by invoice 4971, which, although District Judge Bell ordered it to be disclosed, it wasn't, and the explanation was given that the software had changed, but that's all we know about that. The respondent accepts, and this is their skeleton argument, paragraph 17, that the checkout fee related to the duty that we saw to pay a checkout fee in page 101 in the 2018 tenancy agreement, but of course that obligation hadn't at that stage arisen. And then I'll come on to make submissions about what the nature of the payment must have been in those circumstances. And a similar point can be made about the admin fee, which is twice the £120, and in respect to an event that at that point simply hadn't happened, because the admin fee is in relation to the drawing up of a new tenancy. And in fact, what seems to have happened is that in 2019, a further admin fee was paid. So if this was in some way related to the admin costs permissible then under the tenancy, then the appellant ended up paying 3 times. But I'll come on to deal with that when I deal with the arguments about how the payment should be treated. This tenancy then expired in April 2019, and it's unclear exactly what happened after that. There's some documents that suggest there might have been a further written agreement, but none was produced to the court. It was either a written tenancy agreement for 12 months, or it was a statutory periodic tenancy. Perhaps nothing, it doesn't matter. In either case, it would be an assured short-hold tenancy. And since it predated the 2019 Act, there's no reason to expect that the terms were any different. And indeed, they would have been the same if it had been a statutory periodic tenancy. Then the next stage is that in 2020, a third tenancy was entered into. That was a 12-month tenancy, continuing thereafter for month to month. The terms are at page 71. I don't ask you to turn that up because they're the same as the next tenancy, which is perhaps more material. So if I can, that tenancy continued for a year, and then in 2021, it was replaced by a further tenancy. And if I can ask you to turn that one up, that's at page 49 of the supplemental bundle.
Page
49.
Supplemental, yeah?
Yes. And the terms of this tenancy were materially different from the one that we saw earlier in relation to 2018. And the respondent says, and it's no doubt a reflection of what caused the letting agent to draft or to use this draft, is that this tenancy agreement reflects changes in the Tenant Fees Act, and so it doesn't impose directly any obligations on the tenant to make any payments under the terms of the tenancy agreement itself. And the material parts of that agreement that I ask you to look at are the term, first of all, that's page 49. Which is for a period of 12 months to start on and include the 13th of April, end on the 12th of April 22, subject to a break clause, and thereafter from rental period to rental period, and that's the term. Then at page 51, under part of the tenancy agreement dealing with definitions, we see that there's a reference to an inventory of contents and schedule of conditions, which, well, I won't read it out, but one can see what it says, that it's an inventory prepared by the landlord, and then the tenant's invited to check it carefully at the start of the tenancy. So it's referring to an inventory that is intended to be drawn up at the beginning of the tenancy. Then the obligations under the agreement start at page 53. They're to pay rent and other sums due to the landlord's agent in the manner set out in the agreement, whether it's demanded or not. And then at page 58, there are various obligations that arise at the end of the tenancy, and they reference the inventory in several points. So at 1.48, we see that you've got to deliver up to the landlord vacant possession in a clean and sound condition, and it refers to the contents being as they're listed in the inventory. Then at 1.483, it refers to other articles set out in the inventory or articles substituted for the same. And at page 5, it refers, at point 5, it refers to arranging for the return to the hire company prior to the inventory checkout of any hired rented television. But the other relevant provision is at page 62, where there's a responsibility on the landlord to provide a fully comprehensive inventory of contents and schedule of condition of the property at the beginning of the term. And then there's reference to attendance, and it says the tenant will attend the inventory check-in. In the event the tenant doesn't do so, the landlord reserves the right to carry that out without the tenant.
Yeah.
They'll set the inventory once prepared. So although the term that was in the first tenancy agreement about a tenancy checkout and the tenants being required to pay for the cost of that checkout is absent from this agreement, it's clear that the agreement does contemplate a checkout exercise comprising the landlord checking against their inventory at the end of the tenancy term. And so it's something that is contemplated as happening, and that's an important step in our argument about the inferences that fall to be drawn here.
It doesn't really matter for the purpose of this case, but although there is reference on page 50 to a deposit, there doesn't actually seem to be an obligation to pay it, as far as I can see. It says it's to be held by the agents, but there doesn't seem to be an express obligation to pay it.
Although it's probably implicit in the use of the term deposit. But I hadn't directed my mind to that, but it's
covered by the obligation, which I haven't now lost, to pay to the landlord's agent the rent and any other sums that are lawfully demanded.
Yes, that's, in this agreement, it's page 75.1.2.
Yes, other sums due to the landlord's agent, that may cover it.
Yes, although it does require those sums to be due. And so if there's no obligation, then it's questionable. But anyway, it doesn't arise. Then the 2022 agreement expired in April 2022, but the 2021 expired in 22, but the appellant remained there. We say that that's attributable to the contractual periodic tenancy that one sees in the terms of the agreement. Month to month. It's fair to say that it was described in an earlier pleading and in the tenant submissions to the district judge as a statutory periodic tenancy.
But nothing turns on that.
No, well, what may turn on it is when one comes to look at section 17 of the Act, we accept that the notice has to be served in relation to the tenancy in respect of which the demand, the payment was made.
I see.
And so it's for that reason that the respondent submissions stress that that tenancy should be the statutory periodic tenancy, which they call the fifth tenancy, rather than the contractual tenancy, the periodic bit of the contractual tenancy that we've been calling the fourth tenancy. We say that nothing in the event turns on that because the arguments on inference will be the same anyway. But it's a point of difference between the parties. What the respondent relies on is the schedule of payments at page 66
Of which bundle?
of the supplemental bundle.
Yeah.
Which they say take precedence. But we say, well, there's no reason why they should do. They're just a schedule of payments that set out what's due under the fixed term part of the tenancy. And so the contractual tenancy is the one that takes precedence of its right to use that language. So we set out the history of the proceedings in our skeleton. I don't intend to take you to that. The important point is that District Judge Bell identified the issue about whether the administrative and checkout fees were prohibited payments. The possession claim was then adjourned. The defendant argued that by analogy with superstrike, this case did involve a payment being rolled over to the subsequent tenancies, and the district judge rejected that analogy on the basis that in superstrike, the second tenancy had an obligation to pay the deposit, and therefore that was critical to the inference that was drawn there. So moving on to the statutory framework, again, we set that out in our skeleton. I don't think I need to take you through the provisions about assured tenancies and assured short-hold tenancies. The points we may need to look at are where an assured tenancy is a fixed term, then it's replaced by a statutory periodic tenancy under section 5.2 of the Housing Act 1988. These, of course, are all statutory assured short-hold tenancies because they're post-1996 tenancies, and so section 19A, which isn't in your bundle, has the effect that they're assured short-holds. So I can perhaps move straight on to the 2019 Act. There's a convenient summary, before I get on to that, of the assured tenancy regime, or assured short-hold regime in superstrike at paragraphs 9 to 13 for reference. And the Tenant Fees Act is one of a group of provisions, or one of a group of similar statutory provisions, that prevent a landlord from relying on a Section 21 notice where they're in default of certain obligations to which they're subject. Superstrike's another example, but there are others. In coming to the Tenant Fees Act, if I can ask you to turn to the bundle of authorities. We set out the background to this in our skeleton at paragraph 21. I don't take you to that. It followed a consultation exercise exploring various concerns about a lack of transparency about letting fees that were then governed by different provisions in the Consumer Rights Act
Yeah.
that only bit on landlords' agents rather than landlords themselves. And one of the things that the 2019 Act did was to impose direct obligations on landlords, not to require payments. And so the starting point is section 1, which requires that a landlord, it's page 25, a landlord must not require a relevant person, and the relevant person for these purposes is the tenant, to make a prohibited payment to the landlord in connection with a tenancy of housing in England. But those, then there are other obligations not to require a prohibited payment to a third party, or to enter into a contract with a third party, except in certain circumstances. For reasons we'll come to when we come to section 17, it's only 1.1 which is relevant here.
Well, I'd like to hear the reason because it's a bit puzzling.
We aren't able to supply it, I'm afraid, but it's not immediately obvious why it only applies to that particular species of obligation under section 1. And despite the prohibited payments are defined in section 3 as any payment not in schedule 1, and there's no question here that the payments here, if they'd happened after the 29th.
The deposit is all right because it's below the maximum.
Exactly, yes. But despite the broad wording of section 1.1, there's an exhaustive definition about when a payment is made, or when a payment is required. So section 6, 1.1.6 provides that for the purpose of the section, a landlord requires a relevant person to make a payment, enter into a contract or make a loan in connection with the tenancy, if and only if the landlord requires the person to do any of those things in consideration of the grant renewal, continuance, and so on. And I don't need to go through the remainder of those. The other ones all refer to something, or mostly refer to something done in respect of or in pursuance of a provision of a tenancy agreement, whereas section 6.16a doesn't.
Yeah.
What is a relevant one is 6.116d, which enters into a tenancy agreement relating to such a tenancy which requires or purports to require the person to do any of those things other than circumstances mentioned in B or C, which appears to be something of a wrap-up provision, because if you enter into a tenancy agreement which requires you to make a payment in other circumstances, then it seems to cover everything else, because the other points are to do with default or variation of the agreement.
But you do rely, do you not, on the distinction between subsection B and C on the one hand and A on the other, because B and C require it to be a term of the agreement, whereas A is not so confined.
No, exactly, and it does also raise a question about what the relationship is between A and D.
Yes.
Because and that in turn leads on to the further point that we suggest, although it's not key to our argument, that in consideration of in 1.6a may not have the meaning of strict contractual consideration, because
what it does seem to suggest in very broad terms is that Parliament is aiming to avoid a situation where the landlord wriggles out of the obligation by some ingenious means of imposing the requirement on the tenant, but not through the medium of the agreement.
No, indeed, and there are a lot of ways in which a landlord might express a requirement, and not all of those can be captured by reference to a classic bilateral contract. And it's for that reason that we do raise a question about whether or not in consideration of or here is referring to strict contractual consideration because
So, wait a minute, D refers to entering into a tenancy agreement.
yes,
That's got to be bilateral, hasn't it?
well no it has, but if 16A is read as having the same sense that consideration there means that it's got to be contractual consideration, so that there has to be some bilateral agreement, then at least in a grant case, there's no difference between 16A and 16D.
Well, I wonder about that because 16D is talking about a tenancy which requires or purports to require, because later on we're told that certain obligations aren't binding.
That's right.
So you need the purported bit to catch an agreement which purports to impose an obligation on the tenant, but it's not a binding obligation.
But they would that well, can I deal with that first of all just by showing you the definition section,
Yeah.
or the interpretation section, which is section 28, which is 48.
Section 28.
And that refers to a tenancy, and this is page 49, which it defines as an assured short-hold tenancy other than certain ones, and or a license or a tenancy or a license, and it says, but then it goes on to say tenancy in that as well, and then there's whatever section 16A covers, and section 16A seems to be covering things that stand outside the agreement to grant the tenancy, but it's difficult to see how that can be the case if in a grant case you're saying, well, the payment has to be in consideration in strict terms for the grant of the tenancy, because then it would be an agreement for the grant of a tenancy, and there wouldn't be a difference between the two. And it may be for that reason, or partly for that reason, that the section that my lord referred to, where certain terms are said not to be binding on the relevant person, are to do with terms of a tenancy agreement which breaches section 1, and so it's something has to be within the tenancy agreement before section 4 bites, but it may not apply to something that stands outside that. It's not quite clear what the status is. And part of the reason may be that well, if it's not contractual, then it's not binding anyway. Before I leave this point, just so I don't have to come back to it, we of course see the force of the point that the respondent raises on this point, that when you use a technical term like consideration, then it's normally intended to bear its technical meaning. But the difficulty in this case is that you are talking about consideration which by definition is prohibited. And so it's difficult to see how it can be consideration in that sense. And so it becomes a slightly circular argument. But as we say, we stress our argument doesn't depend on this point, but it does, we say, help to show that the Act tries to capture a wide range of types of payment. Lord, that there are corresponding obligations on letting agents, but they don't apply here. We say this isn't a payment to a letting agent, and if it was, it wouldn't operate to limit the Section 21 notice. There's an issue about that. I'll come to deal with that when I go through the steps in our inference argument. General enforcement is through the Weights and Measures Authority or the District Council. I don't think I'll take you to the provision on that. Then if I think the next step I need to come to is Section 17, which is the provision which applies the inhibition on serving a Section 21 notice.
Yeah.
And Section 17(1), as I've already 1A, it incorporates the meaning of prohibited payments in section 1.1, and so only applies to that species of breach by the landlord. And
Is there any explanation for that?
not that wait, don't have that one. No, not that I'm aware of.
It's odd. But anyway, there
Yes,
it is.
it's I don't think apparent from the government consultation or the response to it, and there's nothing I think about
No,
it
I
in
couldn't
the
see it.
explanatory notes.
But anyway, it is plainly restricted to section 1.1.
No, exactly.
And it doesn't catch any other prohibited activity under any of the other subsections.
No matter what benefit the landlord gets from it.
Yeah.
And the reference to 1.1, as we've seen, incorporates section 1.6 because that's the exhaustive definition of 1.1. So we accept that the landlord must, it follows from section 17.1a, require a payment in consideration of the grant or continuance of the assured short-hold tenancy, and because I'm going to develop my arguments by reference to 1.6a, although if they're good.
And do you accept or not that the tenancy in question is the tenancy which the landlord wishes to terminate?
Yes, and that follows because really from the wording of 17.1 and 17.3 that the requirement has to be in respect of an assured short-hold tenancy, but then when one comes to 3, it says no notice may be given in relation to the tenancy.
The tenancy.
So that must be the tenancy in respect of which the...
So the question here is, did the landlord require the payment of the administration fee and or the checkout fee in consideration of the grant of the 2021 tenancy?
It's, on our case, yes. On the respondent's case,
It's the
it would be in
2022.
consideration of the continuation of the...
But that doesn't matter, does it?
If
legal
our
analysis?
inference argument is a good one, then it works for both tenancies.
Yes.
And so if it's a bad one, then it fails for both tenancies. So that's so we say it doesn't really make a difference. And so there's got to be a requirement to make the payment in consideration of the grant of the tenancy in respect of which the notice is eventually served. That does, my lord, raise a question about whether this is what can be intended, but it's clearly the effect of the section, because it seems to have the effect that in a case where there's been a clear demand for payment on a fixed term tenancy, all the landlord's got to do is wait for it to run out, and then say, well, I didn't demand it in respect of the periodic tenancy, it's now arisen, and they can then serve a notice. But although, depending on the facts, 1.6d may apply, so that it's so the same terms carry forward to the periodic tenancy. But it does raise a question that perhaps is for another case. And the other requirement is that the tenant, being the relevant person, this is 17.1b, has to make a payment to the landlord as a result of that requirement. And the operative provision is then section 17.3, which requires that no section 21 notice can be given in relation to the tenancy as long as the payment hasn't been repaid. And then there are various provisions about set-off operating as repayment, but we don't need to get into those. So, in short, well, we do accept the point that there's a correlation between the tenancy in respect of which the deed was done, as it were, and the service of section 21 notice. There are transitional provisions and provisions about retrospectivity in section 20. I don't think I need to section 30. I don't think I need to take you to them. The Act's not retrospective, but that's qualified so that, broadly speaking, it does apply to payments pursuant to requirements in pre-enactment tenancies a year after the Act came into force. But again, that isn't an issue in this case. So the question then is how do we fit the facts of this case into that framework? And the propositions really start with a set of propositions about the original tenancy and then the application to the later tenancies. We start with the original tenancy because that really defines the character of the payment, and that is something that we say can be traced through the succeeding tenancies. And there are four key points. Firstly, the initial checkout fee, this is the 2018 one, was paid to the landlord and not to the agent, so it did fall within 17(1)(a). There's an issue about that. Secondly, it was conditional or on account of the costs to be met by the landlord of a checkout if it happened. Thirdly, that the requirement to pay the original checkout fee was part of the consideration for the grant of the tenancy. And fourthly, at the end of the tenancy, and since no checkout had happened, the respondent was obliged to repay the amount to the appellant. And that then leads on.
Why was the landlord obliged to repay it with the tenant stayed in possession under another tenancy?
Well, that's where
plainly there was no checkout.
Well, exactly.
Might have been used when that one came to an end.
Well, except that would mean that the checkout, the inference for the checkout would, at the beginning of the tenancy would have to be, well, it's not only in relation to the obligation under this tenancy, but in relation to some other tenancy.
Checkout. It's in relation to a checkout whenever that happens.
Well, except that it's an obligation which is required at the time of the original tenancy, and appears to be in relation to things that are happening in relation to that tenancy.
It's a checkout under that particular tenancy. So if you renew on the same terms, I suppose the parties would have to be taken to have agreed that he could keep the money. If the tenancy was on identical terms, instead of handing the money back and then handing it back again, it would be another repayment on account of the next checkout.
No, indeed, that in a sense, that's the exact analogy with Superstrike.
Okay.
In that, in Superstrike, the deposit wasn't paid for this tenancy and any other tenancy you happen to have. It was paid for the particular tenancy. When that tenancy came to an end, that obligation was exhausted.
Well, that gets you as far as a second tenancy.
No, indeed. We accept that things get trickier after the second tenancy, but that's the chain of reasoning that it's
yes,
and it is an important part of that at the end of each tenancy, the thing against which the money was being held didn't happen, and that's either just repayable according to its terms, or it's a failure of basis case. And there's a certain amount of debate in the skeletons about failure of basis, but it probably doesn't. It's not necessary to travel too far into that, and I'll come on to it. But so those are the propositions in relation to the original tenancy. In relation to later tenancies, what we say is that in the circumstances and in the absence of an explanation from the landlord, the court could and should have held that by retaining the money and not repaying it to the tenant, the landlord required the tenant to make a payment of that amount. And in consequence of that payment, the tenant, that requirement, the payment, that the tenant had made that payment. And we say that the terms require and pay in section 17 can be accommodated in that analysis. Further, so the landlord had required that payment in consideration for the grant of the tenancy. And also that the sum not repaid by the landlord retained its character as a checkout payment to be held against the costs to be incurred on any checkout. And since no checkout in fact happened, the landlord was again obliged to return the payment at the end of that tenancy.
Well, yes.
I can see.
Let's follow that analysis
Yes.
for the moment. So, the first tenancy, the 2018 tenancy,
Yes.
the tenant pays the checkout fee, but in 2019, no checkout actually happens. the next tenancy is on the same terms as the 2018 tenancy. So you say, well, the parties must be taken to have agreed that the checkout fee be paid,
Yes.
and the payment was satisfied by retention of the payment made in 2018.
Yes.
So far?
Yes.
At the end of the second tenancy, the landlord was required to repay the checkout fee to the tenant because the checkout had never happened.
Yes.
The third tenancy did not require the payment of a checkout fee. So why doesn't the tenant still have the claim for the return of the checkout fee paid in consideration of the grant of the second tenancy?
Well, they do.
Well, then that kills your case, doesn't it?
Well, no, because
you've got to find another deemed requirement and deemed payment post coming into force of the Fees Act in order to invalidate the Section 21 notice.
no,
But
no,
if the tenant had a claim to return of the money at the end of the second tenancy, she still got it,
well, she
doesn't she?
well, she would have had a claim. Well, no, because what then happens is that at the end of the second tenancy, or the position is that the landlord is still retaining money which is earmarked for a checkout. True it is, there's no obligation on the tenant to pay a checkout.
Well, why do we know it's earmarked? It's just gone into his pocket.
Well, it's gone into his pocket, but this is a case where the landlord holds money for a particular purpose in relation to the 2018 and 2019 tenancies. When the 2019 tenancy comes to an end, there's no evidence about what no contrary evidence to suggest that the payment changes its character in some way and is being held for some other purpose.
So, all right. So you say when the third tenancy began, the landlord had earmarked the 2018 payment for use in connection with the checkout.
Well, that's what one starts with. That the landlord's holding money that's been earmarked. I've used that term for that purpose. It's a payment which, because it wasn't used to that purpose and in the preceding tenancy, the landlord has an obligation to repay, and there doesn't seem to be a dispute that an obligation to repay could, in principle, arise in those circumstances. The point taken by the respondent is that there was no total failure of consideration, which he says is a misguided approach.
But it doesn't matter. It doesn't matter. You pay it for a specific purpose. The purpose doesn't arise. You pay the money back.
No, indeed. And the way I think the respondent puts it is to say, well, if it was part of the consideration for the grant of the tenancy, you got the tenancy, and therefore that was enough. But that fails to distinguish between two things. One is the obligation.
Work for a deposit, and they can't work. For
No, indeed. It doesn't distinguish between the obligation to make the payment and the terms that govern the payment. And it's the terms that govern the payment which fail.
You see the force of your argument, Mr. Westgate, if the third tenancy had envisaged a similar sort of checkout process to the first two, but had simply omitted any requirement on the face of it to pay for that checkout process. I can see how one might join the dots there. What I'm struggling with is the fact that the checkout, the inventorization and so forth is somewhat different.
It's certainly different, but equally it does envisage a checkout exercise, and that's why I took you to the passages in the.
It's not quite the same checkout exercise.
Well, what it seems to, what it envisages is that there will be an inventory at the start.
Yeah.
And that's clearly set out. And it tells the tenant that it's in their interests to attend and pay attention to that inventory. And then at the end, the obligations are to make sure that everything is in accordance with that inventory. And of course the tenant would then be obliged to potentially pay damages in respect of any breaches in the course of the tenancy.
Well, one can see the common sense behind it, because it avoids doubt or argument later in the day about whether or not the sofa was in a particular condition on day one of the tenancy. But how do you leap to an inference that the landlord was requiring money that he'd already pocketed for an inventorisation exercise under the older tenancy as being for this exercise?
Well, it's the building blocks are in a sense similar to those that arise in respect of the earlier tenancy, although we accept that that there's no obligation to positively to pay for the cost of the checkout. But what the starting point is that the landlord's holding money that certainly previously has been earmarked to pay for the checkout. The landlord they're under an obligation to return that money for the reasons we discussed. And so what has to be explained is why is the landlord retaining that money? And that's the exercise that the inference is directed towards. Now, of course, that's in a context where the respondent had an opportunity to give evidence, but chose not to do so. So there was no explanation. If they wanted to say, well, look, we just forgot about it, or if they wanted to say, well, look, we thought it was money that was paid before the 2019 Act and we were entitled to keep it, then they could have said that. But there are no explanations.
We're imputing to the landlord a purpose on the creation of the 2020 tenancy to retain this money in order to pay for a checkout.
Well, yes, and then the stage that we, or the staging points in that argument are first, you have to explain why the landlord's retaining it. You can't assume that the landlord is disregarding their duty to return the funds.
Yes, but can I just ask the question?
I'm sorry, my lord, yes.
That's a purpose which would be unlawful, would it, after the Tenant Fees Act came into force?
Yes, it would. In that, if as we say it is, it's a requirement to pay money to do that. It would be prohibited, but it seems it doesn't fall within the unenforceability provision in Section 4, but it's certainly prohibited by the Act, and it's liable to give rise to a penalty. And if you do it again, it's potentially a criminal offence.
So you're having to impute
yes.
to the landlord a purpose, which in fact would be unlawful.
Yes, it would certainly be a prohibited payment within the Act. But then that's not that's not something that stands in the way, in the sense that it quite often happens that parties agree something or are taken to agree something, or the consequences of what they agree are consequences that surprise them. And that end up incurring liability that and if one were to say, well, you can never impute anything that would turn out to be a breach of the Act, then it would mean that the Act would only ever bite on express provisions, and then that would be, we suggest, wrong in principle. And so that for the purposes of deciding what should be imputed or inferred, we suggest that the starting point, at least, should be to not have regard to the Act and have regard to what the parties must have been taken to have intended, apart from those superimposed obligations. And so the staging points are.
Did your client ever actually ask for the money back?
There's no evidence of that. That's right. But so the landlord retains the money. It can't be assumed they disregarded their duty to to return the funds, if that was the obligation they were under. And so it's got to, that there has to be some basis on which it can be said that the landlord purported to retain them, or in a way that they would have been entitled to do, leaving aside the Act.
So this argument imputes to the landlord the legal knowledge that he's required to return the payment, but ignores any possibility of legal knowledge that the retention of the payment might be unlawful.
Well, it's not necessary to impute any detailed legal knowledge about.
No, not detail, but you say you can't assume the landlord ignores his, your word was duty.
Yes.
I assume that means legal duty,
Yes.
to return the money. But you do say that you should ignore the landlord's legal duty not to require the money.
No, we do say that because the Act, otherwise the Act becomes unworkable, because it talks about requirements and agreements which are by definition unenforceable. And so in deciding what people have agreed, if you were to say, well, they can't have agreed it because it would be a breach of the Act, then the Act would never bite, because you'd say, well, there's never an agreement. And so in order to maintain the coherence of the scheme, one has to put it to one side when deciding what someone has agreed to.
Do you pray in aid the fact that no other possible explanation has been put forward as to what they had agreed or the purpose for which this money might otherwise be retained?
Yes, we do, and we've cited in our skeleton argument various passages from Prest, citing Harrington and Coombs, and those, although there's a degree of disagreement about whether or not Harrington goes too far, they support the proposition that the court is entitled to draw inferences from, or that would support a hypothesis based on the evidence, or what would reasonably be the balance
But I
of
think,
probabilities.
is it FOB, which makes it clear that the court is not obliged to draw inferences? It can, but it's not obliged to.
No, exactly. Ultimately, it's a question of fact.
Yeah.
What's a and
Well, that's another problem you need to confront, isn't it? The district judge, deputy district judge, didn't draw these inferences of fact, and so your appeal essentially is one on the facts.
well,
Isn't it?
it's the way we put it is that is that the district judge.
Should have drawn these
Well,
inferences.
we do say the district judge should have drawn them, but the route we get to on that is the district judge cut short his inquiry, in that he said, well, this isn't like super strike, because this isn't a case where you've got an identity of terms between the two tenancies.
Right. So if we are with you,
Yes.
we send it back for some fact finding.
It would have to be sent back. And so what we're putting forward is a chain of reasoning that is open to the court. But I'm not saying that this is a case where it's the only possible conclusion the court could reach, or that it would be perverse not to. And so it would have to go back.
Yeah.
But to come back to Milady's point about the question of adverse inferences in the absence of an explanation, yes, we absolutely do, and that's an important part of our inference journey, as it were, in that if somebody fails to give an explanation when they could have done, and it's important perhaps here to note that the order of District Judge Bell not only required disclosure of the invoices, but also that any evidence should be given, and that made provision for statements to be put in. And so the landlord had an opportunity to give an explanation. They didn't do so. And in those circumstances, they can't complain if the court draws inferences based on the not unreasonable proposition that a landlord doesn't intend to keep money they're not entitled to. And if they do decide to keep money they're not entitled to, then there must be some basis for it. And they must be expected to have given something in return for it. And those, in turn, give us the building blocks of the inference we invite the court to draw. So to come back to so it can't be assumed they disregard their duty. Got to be some basis, therefore, on which they purported to retain the money. And since the new agreement still contemplated that the landlord would incur costs, and they were holding funds that had originally been designated to meet those costs, then the inference should be that they continue to be held for their original purpose, which is payment towards a checkout inventory if and when it happened in relation to that tenancy. And we do accept that the description of the checkout inventory changes between the first and the second, or rather the second and the third tenancies. But the third and fourth tenancies certainly do contemplate an exercise at the end of the tenancy where the landlord goes in and the landlord checks what's happened.
And where is the requirement to be found?
The requirement comes in the landlord keeping the money and in effect helping himself to the funds. But it's if I can come on to deal with that separately, my lord. Just can I finish my point on the inferences we say need to be drawn, and then come on to deal with the. So I was at the point about this has got to be treated as having its same character, as it were, and we say that is supported by the fact that even after proceedings were issued, this was a payment that continued to be described as a checkout fee. It may be that's there's an email of the 24th of January this year at page 15 of the supplemental bundle. It's in response to a query, and it arguably refers back to the earlier designation. But there's never been any suggestion this is something else, or that it's been dealt with in some other way. We accept that there's no discussion or express agreement between the parties, but we suggest that superstrike shows it's not necessary to find that in order for the court to fulfil its function of filling the gap by inferring that this is what the parties must have been taken to have assented to.
Well, the trouble is that in superstrike there was material from which one could easily find that there was a requirement, because there was a requirement to pay a deposit.
No, indeed, and we accept that in superstrike there's
that's the link, and it seems to me that that's the difficulty, is inferring that there is a requirement and a payment in response to a requirement from inactivity, complete inactivity. Because requirement seems to me to involve a conveyance of a wish by one party to the other that something should be done, and the payment in response to the requirement obviously is the doing of that which is conveyed to the other party that the landlord wishes to happen. And just passiveness is a bit difficult in the absence of just from my point of view, in the absence of a contractual requirement from which one can draw the inference, is a little bit difficult to go to that stage.
The other, sorry, before you
Yes.
answer my lady's question, the other point is that I don't think superstrike turned on the question of requirement at
No,
all.
it didn't. The question was
There was a provision of the Act which talked about requirement, but what superstrike turned on was any tenancy deposit paid in connection with a short hold
yes,
tenancy.
it was paid and received.
Absolutely. There was nothing to do with requirement.
No, that's right. That in superstrike, all the court had to do
Ask itself, was this deposit paid in connection with the tenancy?
yes, and then it also had to consider receipt, I think, because
Yeah.
that would trigger the.
Exactly, and it was argued that that meant, as it were, real receipt, and we said no,
No.
it can be a notional receipt.
Yes, and so Superstrike demonstrates that terms like payment and receipt don't.
Are flexible.
Yes, and they depend on their context, and they don't necessarily require physical or some accounting
So,
exercise.
Now, my lady's question: where's the requirement?
Well, it's first of all the require we suggest doesn't bear the meaning of require or that there's some the term used by the respondent on this is it's a deliberate imperative act. And so it doesn't require that level of demand. Require simply is something that's needed or wanted or that's compulsory. It's an ordinary word. And so if we accept unexpressed objective understanding to be inferred is to be taken that the respondent's retaining the funds as a checkout fee, then the respondent is compulsorily requiring them for that purpose. And the retention amounts to payment even though no money changes hands. And as we suggest in our skeleton at paragraph 52G, the language of payment or require can be applied to a case where a landlord retains funds without giving any choice to the tenant. And in fact, in one sense, that's a paradigm case of requiring them, because the fact that the tenant has no say in the matter is something which simply underlines the fact that there's a requirement both from their point of view and from the landlord's point of view.
Which would work if the tenant had demanded the payment back and had been refused. If the tenant says nothing at all, how do you infer or imply a requirement out of that?
Well, it depends on whether there's got to be some requirement which is impliedly communicated to the tenant, and what we say is that that's not necessary, because require here simply means it's something that has to be done, and so it's something which can be produced by the unilateral act of the employer.
Why does it have to be done?
Well, because the landlord is working on a basis where they give the tenant no choice in this case. Because what they do is they retain the money. There's no express agreement between the parties, and we know that there's no discussion. But one has to consider, well, what again, absent the act, if there had been this kind of discussion, then what would it have produced? Because that's the inquiry that happened in Superstrike. It's paragraph 39.
It might have produced the landlord saying, "Oh, my ears and whiskers, we've forgotten to pay you back this money. Of course, you can have it." Or it might have produced the the landlord saying wrongly, "Well, we're entitled to keep this money because you've got the tenancy in consideration for it," and then you have a bit of a spat about it in court and you win.
But in circumstances where, and again, this brings us back to the absence of explanation, that in circumstances where the respondent's chosen not to give evidence, they can't complain if the inferences are drawn are the ones that are unfavourable to them.
Right,
Well,
shall we
I don't know if
stop
you-
there for the moment?
Certainly, yes. And I think I don't have a great deal further to go.
Oh, all right, fine. 2 o'clock.
Yes.